Well, good afternoon, good evening. Uh, Welcome to Chapter 8. This chapter is going to be talking about some of the different criminal punishments, and I'll also be talking about some in North Carolina. In the folder for this week, I will try to post some links to North Carolina structured sentencing and a few things, but when we get there, I'll talk about that some more. Again, we've got the learning objectives, and I've told you 7 times before, they're not critical for going through this, but I think they're helpful, and it wouldn't be a bad idea to review them before you start. So, let's talk about punishment in a historical perspective at first, because most of these chapters began with a historical approach. We've got this nice picture of some stocks, and I assume that's an English village. I'm sure that the stones might be original, but the wood is not, because they haven't done stocks in England for quite a while. It was very common that people sought private justice. One of the things about the justice system is that it is a substitute for individuals taking the law into their own hands. It is a community-sponsored, a state-sponsored alternative. The hope, of course, is that both in the apprehension, the trial, and the punishment, that a fairer system, a more just system is created by removing it from the public. Removing it to the public from the private. So, traditionally, many crimes were punishable by death. It was a very preferred sentence for courts. One of the examples I like to use is if you look at an American quarter, you'll notice that the American quarter has ridges along its edge, tiny little ridges. These ridges were to prevent people from, with silver coins, not necessarily today, of course, with American coins, but in the old days they were made of solid silver, and what you would do is you would take a knife, because silver is a very malleable metal, you could cut the silver, or what was called crop the silver, just a little bit off each one of the silver coins. If you were caught doing this, the penalty was death. So these little things reverberate in our society. Bits and pieces of them remain. Neither was the methods of execution particularly nice. There were extreme cases of probably the most familiar case you might have seen was the movie Braveheart, although that's getting a little old now for many people to have seen, in which you saw William Wallace, who was deemed to be a traitor to England, although not to Scotland. He was partially hung, then he was split open. His intestines were taken out and shown to him and thrown on a brazier. And then the quartering, which would be they would tie a horse to each one of his limbs and whip them so that it would go in a different direction. There was also beheading, which was seemingly, if you compare it to what I just talked about, a little bit nicer. And of course, there was burning at the stake. Lesser punishments typically took the form of physical mutilation. So there was cropping. Now this was slightly different, although you can see where the term relates. Removing parts of the ear, blinding, amputations of hands, physical marking or branding was very common as well. Also for some crimes, whipping. If it was a military crime, for example in the Royal Navy, you had keel hauling, which was you would take someone and throw them off of the side of the ship, sometimes off of a mast, which could be 40, 50 feet above sea level. They would fall, they would have a rope tied on one side of the ship and then tied on the other, and they would drag them underneath the ship and pull them up the other side, which doesn't sound terrible to remember that these ships were often encrusted, their keel was encrusted with shellfish, different types, barnacles, so that people very rarely survived this. So there was a tremendous amount of pain, mutilation, and killing going on with punishment. In the 12th century, there began to be kind of a split. And you have this term, it means something a little different today, and I'm not going to confuse you by talking about benefit of clergy today, but in the 12th century, there was really a struggle for political control between the political authorities who were represented by the king and the ecclesiastical authorities that were represented by the Pope. So gradually it was decided that if you were a member of the clergy, and that could be a very broad category, it could be someone who just read in church, it could be a clerk of a church, it didn't have to be just the priest. Um, the the benefit of clergy developing said that the royal court could try you, but because you were a member of this ecclesiastical community, they couldn't execute you, at least for certain crimes, certain times. And what happened with this benefit of clergy was it began to expand. So, as I said, at first, I guess it was really just the bishops, priests, the prelates. But gradually, it became almost anyone who could read, anyone who had any connection to the church, even a very tenuous one. Um, in part because of the Reformation in the 16, going over into the 1700s, this eventually was eliminated. Um, but it was really kind of the first tentative step forward to saying, well, let's think about how we can put a check on all these killings and mutilations that we're doing in the name of justice. Another thing that developed with regards to punishment, and I do love that your book talks this much about history, although again, you're going to see some of these reverberate in America today, and I'll talk a little bit about it. Um, the law of sanctuary and the right of asylum. Now, I guess the one that many of you would have seen would be the Disney cartoon Quasimodo. And if you recall in that, Esmeralda the gypsy was being chased by a Parisian mob. She managed to get to the Cathedral of Notre Dame as Americans call it, and because she got there, she could claim sanctuary. Um, Sanctuary was the idea that someone fleeing, um, whether from public authorities or not, if they could get to a church or a monastery or a cathedral, they could claim sanctuary inside its walls. They could not be physically removed because the authority of the state stopped at the steps of the church. Gradually, this was expanded a little bit to include asylum for certain refugees. Now, the the idea never became a firm part of American law, and in fact was ultimately abandoned and abolished in England in the 1600s. But again, as I said, how these weird things kind of reverberate through history. The United States does recognize, or did until recently, that if you were fleeing another country and if you had a well-founded fear of persecution, say because of your religion or because of your political beliefs, you would be granted the right of asylum in the United States if you could get here. Now, this has been dramatically attacked lately, and one of the questions that's been raised is, well, when are you running because you're afraid, and when are you running here because it's just better here? And sometimes those questions are intertwined. You may come from a really awful place where there's no rights and people are beaten or abused or tortured or killed. And you may run to America, and the Americans might say, well, yeah, it's bad there, but aren't you coming here just to make more money? or to make money, period, because economically things are bad at home. And sometimes there's two messages there. But basically, if you're an economic refugee, you don't have a right of asylum in America. But if you're a political, a religious, fleeing from violence, then you might have this right of asylum. There has to be a hearing about it. It's a very contentious issue in America today. All right, another alternative, and then after this we're going to start turning closer to America, is transportation. By the time the England actually had what was called the First English Empire, then you had the Second English Empire. There's not a big timeline division, but essentially, as England acquired these empires, different places, one of the things they said to themselves was, well, gosh, why do we want to keep all these convicts here? Because sometimes by the late 1600s, early 1700s, they were starting to think about cutting back on mutilations and beatings and beheadings. And by the latter half of the 1700s, they were thinking about things like imprisonment. But that's expensive. So what they decided to do was start sending these convicts, these people committed a crime, instead of executing them or imprisoning them, overseas. So and one of the American states, Georgia, was actually founded in part by Oglethorpe as a penal colony, that people who had committed crimes would be transported to Georgia. So we can see how little history changes today. Sorry, I had to pick on Georgia for a second there. It's a wonderful state. And the same thing was repeated with the sort of Second British Empire, where when they didn't, after we left, after we had our revolution, the English said, well, we don't have Georgia anymore, but we've got Australia. So hundreds of thousands of people were expelled from England to both the United States or what became the United States, the Americas, and to Australia, just to get them out of England. And when they got here, sometimes they were indentured servants for a while. Sometimes they didn't have a lot of restrictions. Very often they did, particularly later. But it was a cheap alternative. It was also a way in which you could colonize other places. Okay, let's talk about America, because America doesn't just exist starting in 1776. America starts in the 1600s. We have the failed colony at Roanoke in North Carolina, America's first colony, or what will become America's first English-speaking colony. And then we have successful colonies up in Massachusetts at Plymouth and down in Virginia at Jamestown, although Jamestown will be abandoned. And of course, when the English settled, they brought over their legal system with them, but it adapted to the situation. So I could mention two quick adaptations. In England, slavery had died out. There had been something called villenage. There had been a few concepts, but it really had ended by the settling of America in the 16 and 1700s. But of course, in America, because in part there was a scarcity of labor, and I would say not necessarily a scarcity of labor, a scarcity of people who would do really hard labor, difficult labor, slavery was brought over, and in the American colonies, slavery was recreated. Now, also in America, in part because of this scarcity of labor, it was thought wasteful to really execute people. So it was seen as a much better idea to take someone who committed a crime, maybe not a murder or a really heinous crime like treason, but it was thought of as a much better idea to put them to work. And this is something, again, that kind of reverberates in America, that work is better, work is better, work is better. Work makes you a better person. This is something that'll embraced by the Quakers later and others, but it's a common theme in America's approach to punishment. Most colonies also had a variety of corporal punishments, whippings, beatings, brandings, and again, you probably in high school read the Scarlet Letter or something like it. The Scarlet Letter is all about that sort of marking. Hester Prynne, if you recall, was an adulteress because she had an affair with um, the minister of the town and was forced to wear a letter A. Um, so this went on, and it was also used on slaves and American Indians we attempted to enslave them as well. So punishment came over from England. It was changed somewhat. It was adapted to the situation. And then we have the American Revolution. Um, this takes place not in an intellectual vacuum. So at the same time, America declares its independence and writes down the Declaration of Independence and the U.S. Constitution and the Bill of Rights. There's also a movement, the Enlightenment, going on in Europe, European thinking. And this is an embracement of reason. And you can see some of this in the American Constitution, where they started to stake out um, really parts of this Enlightenment philosophy. So in the Bill of Rights, for example, you will see clauses like excessive bail shall not be required, nor excessive fines imposed. And here's probably the most famous one that plays right to our wheelhouse today. No cruel and unusual punishments inflicted. Of course, as I've said before, teaching this, there's no asterisk there that says, and this is what is cruel and unusual. It just says you can't have cruel and unusual punishments. It doesn't say what excessive is, excessive fines or excessive bail. So again, that's something that America is going to struggle to talk about. So then we have a discussion point here. What do you have to do for prisoners before it becomes cruel and unusual? What do you have to feed them? Um, can you give them food which is basic substance? It'll keep someone alive, but it's terrible to eat and terrible tasting. And this isn't an argument about do you give them lobster, pâté de foie gras. This is an argument about do you give them something that is somewhat palatable. As an aside here, and again, this is the historian in me coming back, although most people don't know this, is that in New England in the 1600s and into the 1700s, lobster was so common, and it wasn't really viewed as a great delicacy, but it was such a common sea catch that they actually enacted laws that said it was cruel to feed prisoners lobsters 7 days a week. Now, if you're a seafood junkie like me, the idea of lobster 7 days a week, I guess, is attractive, but I guess if it was 7 days a week for 10 years, I guess it wouldn't be so attractive. So you can watch this video about Neutraloaf and using food as a mechanism. So let's go back to the Constitution, though, to what is not punishment. The big thing here is the Eighth Amendment of the Constitution. We've already quoted it before. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Now, this is the constitutional limit on punishment. But again, any law is subject to interpretation. And currently on the court, you have really two large groups. One group, and I'm going to grossly simplify this for the purposes of not going into a long constitutional discussion of originalism and textualism and living constitution. But the two groups, one group says you should read this as it was written in 1791. So what's not excessive bail in 1791? What's not excessive fines in 1791? What's not cruel and unusual punishment in 1791? That's your standard. So if you could do things then, you can do them now. The other group, the living constitutionalists, would say, no, you have to reinterpret this for the society as it exists today. That while you can refer to the past and you can use it as a guide, it can't be controlling. So the Constitution is not the ending discussion of this. In many ways, it's the beginning of the discussion of punishment. One of the things that is talked about is proportionality. So the proportionality principle is when a crime is challenged and you say the crime is really minor, the punishment is very great, therefore it is cruel and unusual. Now, in many ways, this is second guessing the legislature and the governor of the state, because don't forget that legislatures are elected. They are the reflection of the will of the people. And what you're saying with proportionality is they got the proportionality wrong. If they have a law that says it's illegal to steal a pair of hedge trimmers, and if you do, it's punishable by life without parole, you might think, well, that's pretty unproportional. That's pretty disproportional. That would violate the proportionality principle. Well, in fact, there is a case I just read out of Louisiana that exactly that issue was raised. An individual who had 2 prior crimes, not major crimes, but prior crimes, stole a pair of hedge trimmers, didn't kill anybody, didn't stab anybody, and I believe it was Louisiana. Under Louisiana law, they have a 3 strikes you're out law, the result of which was he got life without parole. The result of that was reviewed by the Louisiana Supreme Court, and I think it was a 4-to-1 decision with 1 justice dissenting, the majority of justices said, no, it doesn't violate proportionality. That's what the legislature of Louisiana wanted. They wanted a 3 strikes you're out law. It's okay. So this is an ongoing thing where society has to both interpret and reinterpret and look at these things over and over again because it's not fixed. Now, sentencing and jury trials, and this is something we could spend a lot of time talking about, but I think I'll leave that more for the court evidence and procedure class. You've got a number of cases here that are pretty important. The Apprendi case, the O'Brien case, the Blakely case, the Booker case, all of these look at how much authority you can give a jury, how much of a decision they can make. Because you really have a split system if you have a jury trial. The jury determines the facts. The judge determines the law. So if there's an objection about, say, the admission of hearsay, it's a legal question. That is up to the judge. If there's a question about whether an alibi is true, that's a factual question. That's up to the jury. But one of the issues can be, and we could skip ahead and talk about the death penalty here, is, okay, a jury will determine, did an individual commit the crime of murder? And then they will tell the jury, does he warrant death? Here are your 2 options, life without parole or death. That's called a bifurcated trial. So we do use the jury, but we have to be a little bit careful because we don't want to intrude too much on the side of taking the power away from the judge, because he's a trained legal professional, and neither do we want to leave it completely up to the judge. Although I will say, as a fair aside, North Carolina just passed a constitutional amendment allowing people to waive jury trials, and I think in the future jury trials will get rarer and rarer. Trials in general become rarer and rarer. All right, well, let's move on from that, which is kind of a minor point, to corporal punishment. Corporal punishment is the infliction of physical pain, and the example your book gives, such as whipping or dismemberment, and it says this has been abolished in the United States, and that's true, it has been, but not completely. The court has not said that corporal punishment in all cases is unconstitutional. One of the examples, for example, is school. One of the examples, for example, is, what a terrible sentence, I apologize. Many states, including North Carolina, retain language in their general statute that allow a public school to spank a child. And of course, religious schools in America do this more than public schools. Some public schools have completely stopped it. What I think is interesting about this, and we'll get more to public schools, corporal punishment in just a second, is I've thought some about this, and I wonder, is corporal punishment worse than incarceration? I think incarceration can be seen as a kind of punishment of the mind, locking people up for long periods of time, not inflicting a physical pain, but inflicting the mental pain of confinement. Whereas corporal punishment, as it was practiced, was a physical pain. Now, it was fast, and the interesting thing was corporal punishment was over, unless you had a mutilation. But our punishment goes on and on. We have more people locked up than any society on the planet. We lock them up for longer periods of time. So I think you could at least engage in a discussion about, is corporal punishment really worse than incarceration, particularly if the corporal punishment is inflicted in a way where it's not permanent, where it's not a disfigurement or a maiming. As I said, this is an intellectual discussion to have, and I am not purporting that we should bring back the whipping stocks. I'm just asking you to think about corporal punishment in a little bit different way than an instinctive reaction of it's wrong. Having said that, I guess let's talk about one of the uses of it, and that's in schools. Can you use corporal punishment in schools? Well, it is limited. You are required to have some sort of procedural due process. The court looks upon much of this with skepticism. When we talk about due process, and I guess we have to have this aside here because it's there, it's in the slides here, and I think it would be helpful to frame both those words for you. When I'm talking due process, I may be referring to procedural due process, I may be referring to substantive due process. So quickly, in the abstract, not necessarily talking about corporal punishment, what do I mean? Procedural due process is the way something is done. If you have a trial that was a trial by ordeal or combat, where you accuse someone of a crime and you threw them in the water to see if they drowned, and if they didn't drown, you fished them out and they were guilty. That's a crazy way to determine the truth. So we would say that would violate procedural due process. Just like in a more practical way, if someone was physically coerced to give a statement, tortured, they give a statement, now we seek to admit the statement against them, we would say, no, I'm sorry, that really is not a good thing. That's a procedural due process. Now, substantive due process, and I guess we'll focus this back on punishment. Substantive due process says the law itself is bad. Not the way you get there, not the way you determine guilt, not the way you determine whether corporal punishment in this case would be imposed, but what kind of corporal punishment. So usually, substantive due process, the term you see over and over again is what was done here was a shock to the conscience. That what punishment was being actually imposed was so severe or so bad that we would say it just shouldn't be allowed. So it's not the fact you're being punished which is wrong. It's not even the fact that led you to the point of punishment. It's the actual imposition. Okay, you've got this discussion question there. I guess we can use this before we get to the use of corporal punishments in prison. And this is really all about Tiffany being sent. Tiffany's a student at South Elementary. And she's sent to the principal's office and she's paddled for talking back to one of the teachers. Her parents sue. The school district allows it without a prior determination of some violations. And here's the issue. Okay, there's just the accusation. Oh, Tiffany talked back. Here's a note. You go to the principal's office, the principal gets a note. Oh, Mrs. McGillicuddy said that Tiffany talked back. All right, I'm going to spank you. I'm going to paddle you. Well, the school district corporal punishment says there that you can have punishment without determination they violated the rules. What you've got here, ironically, if we refer back to the previous one, is you've got the difference between procedural and substantive. It may be substantively okay to punish, paddle, but did they meet procedural due process? Okay, let's talk about something a little bit closer to criminal justice. Let's talk about the use of corporal punishment in prison before we move on to big dog capital punishment. It's clear that corporal punishment occurs in prisons. Isolation, confinement, restraint, all of these are tools that are used in prison. You do see cases where prisoners claim that there is a violation of substantive or procedural due process in arriving at corporal punishment in prison. However, the standard is much different in prison than in school. Whereas you would never be allowed, one would hope, to handcuff, gag, and bag a student in high school prior to paddling them, this certainly could be done in a prison because we don't look at the same community and legal constraints or standards that you see in prison. So we still see this. Now, one of the big issues here that I think you're going to see a fight about in the next 20, 30 years in the United States as it winds its way through American consciousness is the imposition of solitary confinement. Well, first of all, America largely had abandoned solitary confinement until the middle part of the 20th century because it was seen as both ineffective, expensive, and debilitating. But it has really come back into the American system with a vengeance, such that America now practices it almost routinely, and there are thousands of American inmates in solitary confinement. And we are looking at the practice now, and we're asking the question, does this violate cruel and unusual? Well, probably not in 1791, probably so by 1891, maybe in 1991, and today, well, that's up to you as a society to judge. All right, let's move on to one of the sections that many of my students find the most interesting, and that's going to be capital punishment. You have to start with this. The Supreme Court of the United States, of course, interprets the Constitution. And the Constitution is what the Supreme Court says it is. The Supreme Court of the United States has never ruled per se, which means automatically, that the death penalty is a per se violation of the cruel and unusual. That doesn't mean the Supreme Court hasn't ruled that some applications of it or the broad practice of it has not violated cruel and unusual. What the Supreme Court has done is they have mandated a certain structure, and they have mandated that it can only be applied in certain circumstances. So the really big thing it did was it said, first of all, you can only execute someone for an individual crime. You can only execute someone for what's called a capital crime, which is murder. The person that is hurt has to die. If they don't, you don't execute a person. Now, there's a few very rare exceptions to this. Treason, espionage, you're never going to see that case. But in almost all cases, you can have very heinous acts. Rape, assault with a deadly weapon. Those crimes can't be punishable by death. The Supreme Court has said no. So the first thing is there's a limit placed that the death penalty only applies when you kill. Having said that, now keep in mind we just talked about substantive and procedural due process. The Supreme Court will also require the states and the federal government to follow procedural due process, how you arrive at the death penalty, and how the death penalty is imposed. And then substantive due process, is it fair to impose this? So if you impose the death penalty for jaywalking, You might follow all the procedures, you might meet procedural due process, but the court would say, no, sorry, both it violates proportionality and it's a violation of substantive due process. One of the things the court has said is that you can look at aggravating, but you also must look at mitigating standards. And the mitigating factors are the things that often require that the states not impose a death penalty. So things that can make it worse is, and you can consider this, is was it a depraved type of crime? Did you violently rape and brutally stab? That's different than did you run someone over with a car? Did you do it for money? Which really, if you're killing someone for money, if you're a hitman, that's clearly a premeditation too. Was the individual a police officer? Did you have multiple individuals? Did you do it while committing another felony? It's called the murder felony rule. All of those can be aggravating factors that can push a homicide from, I guess you would say, the standard of a life sentence to death. Now, you also have to consider mitigating standards. Now, these mitigating factors are things that will often prohibit the imposition of the death penalty. So, how old is the defendant? Was he 10, 12, 13, 14? What is his mental state? And what's his past record? These can all be looked at to really prohibit it. One of the things that happened in 1994 was then President Clinton signed the Violent Crime Control and Law Enforcement Act, in which the number of crimes for which you could be executed for, and they had to be predominantly homicides, was increased. So we had more potential federal death penalty charges. And this went along with a kind of realignment of what was going on in criminal justice. Now, the Supreme Court of the United States has really started to weigh into the death penalty starting approximately halfway through the 20th century and continuing through to today. And it has set some broad limits as to when you can and can't execute. So it is said, for example, you can't have the death penalty if, number one, and this was relatively recent, it's late 20th, early 21st century for all of these. One, if the person killing was under 18 when the crime was committed. If the person was actually insane at the time or at the time the execution is taking place. If the defendant suffered from severe mental retardation, or even in the case where it was a very heinous crime like the rape of a child, but the child didn't die. Each state is allowed to decide whether they will or will not have the death penalty. Now, for a while, the death penalty had been advancing. It had really been challenged in the middle part of the 20th century. Many states had abolished it. But then, really starting in the 80s and 90s, it came back, and now it seems to be receding again. So states have recently abolished it, but still a majority of states have the death penalty. It's up to a state whether they have it. Having said a state has it doesn't mean they use it. Some states use it routinely. Number one is, and I guess always will be, Texas. The last statistics I looked at was there were, in the latter half of the 20th century, beginning of the 21st, there was more than 500 executions in Texas. You take a state like California or New York, and there may not even be a tenth of that level of execution. So in New York, I think, just abolished it, if I'm not mistaken. So some states use it a lot, some states don't use it at all. So you can look at this YouTube, and it really talks about how capital punishment is a very emotional issue. And I do think it strikes as something very visceral in people. And the question can be, should you separate it? I mean, we are emotional creatures. We make emotional decisions. People sacrifice themselves for love. They will dive into the water to save a drowning child because they love the child. Doesn't mean that emotional response is wrong, does it? If we make an emotional decision, if we say, well, I can't let someone starve, so I will feed him, That's an emotional decision. It may not be a logical one. You don't look down on that. So when we start talking about emotion here, it's not fair to say, well, we need to keep all emotion out of it. So again, you can watch this YouTube video. I'll leave it for yourself to take a look at. But let's move away from capital punishment again, and let's take a look at the most common form of punishment beyond probation, which is imprisonment. Here, there's less of a standard, whereas I think a court would intervene much more if you had the death penalty for jaywalking. If a state decided, jaywalking is a really bad thing and we're going to have a 10-year sentence for it, most courts would uphold that. It's kind of what's called grossly disproportionate to the crime. We have pretty much let the states make the decisions. Now, some of this can smack of poorly thought out or vengeful or systemic problems, but we let states do it with some limits. For example, you can't impose a life sentence on a juvenile. We also have the issue of fines, and this is something that we're going to turn to this right now. This is something that's really come back. Monetary fines payable under conviction are very frequently used. So when I used to do some defense work, it was very common that someone, even accused of a DUI or accused of a simple assault or something, would have a fine associated with it. There are limits on this. The Eighth Amendment, remember, says you can't have an excessive fine, but the issue becomes here, well, what's excessive for you and what's excessive for me? If we're talking about is the death penalty excessive, you and I only have one life. Your life and my life have some sort of equal value, but I might have a lot of money and you might be very poor. So if I give you a $500 fine and I have a $500 fine and I make $1 million a year and you make $100 a year, you can't pay that fine. For you, it's excessive. So the question is, do you judge this excessiveness based upon everybody or not? Or do you do it individually? So excessive fines are determined by the amount of fine to the gravity of the offense first, and the range of fines and sentences available. Now let me give you, and maybe this will be something I'll think about posting as a discussion question. Florida recently passed a constitutional amendment that made it very much like North Carolina. In North Carolina, if you have served your sentence and you are out and your probation is over, your rights are restored. You are a fully functioning citizen, minus, depending upon the type of crime, some rights to own firearms or requiring you to register if you're a sex offender. But you can vote. You can participate. Florida just passed a constitutional amendment that said, okay, yeah, people who are convicted of crime, have served their sentence in prison, and get out, can vote. But the Florida legislature said, well, no, I tell you what, some of these people are poor, they can't pay their fines. Until they pay their fine, they can't vote. So they might have served their time, but they can't come out and vote. So we get into an issue here about fines is, well, how far down, how long can this follow someone? Then we have an issue of forfeiture. One of the things that has been done lately is seizing things involved in crimes, particularly drug crimes. So we do things like, okay, you use this boat to smuggle drugs into the United States. We're going to seize the boat. So we have federal statutes and we have state statutes that allow you to do this. Now the interesting thing is that these are deemed to be civil. So we're not proceeding against you in a criminal sense. I don't have to prove beyond a reasonable doubt you used the boat to smuggle drugs in. I just have to prove civilly you did it, which is a pretty low standard. And you might say, well, I wasn't smuggling dope. I wasn't, using this car to commit a kidnapping or to smuggle drugs. And essentially, since it's civilly is a relatively minor standard compared to criminal. It's not proof beyond a reasonable doubt. It's preponderance of the evidence. It's a very low standard. And it's really allowed the governments, the state governments, to seize billions of dollars. All right, let's talk about repeat offenders. This is the whole idea of, we'll reintroduce the term in the next slide, recidivism. Taking repeat offenders off the streets can reduce the incidence of crime considerably, at least certain crimes. And many states and many cities have created criminal career programs to focus on high-rate offenders. Now, the actual term, and we'll skip to the next one right away, is recidivism. This is the rate at which people who commit crimes and are caught and punished, after their punishment is over, come back and commit more crimes. So we have attempted to deal with this. Sometimes what we do is we punish more. So some states say there's no parole for prison inmates. We're not going to risk recidivism. All states make the fact that you have prior convictions part of a sentencing enhancement. You will get a longer sentence in North Carolina if you have committed past criminal acts. We have a structured sentencing grid. And again, I'll try to post this North Carolina structured sentencing grid in this folder. Most states, virtually all states, have a 3 strikes you're outlaw. And the federal government has this, where if someone has committed a 3rd felony, you can get a very long sentence. Including, as the example I gave you recently, if someone has stolen a pair of head trimmers and it's their 3rd crime, you can give them 25 years. That was Louisiana. There was a case out in California where a guy stole an ice cream cone from someone, which was a felony because it was from their person. He didn't steal ice cream from a cart that was unattended. He took it out of someone's hand. Because he had had 2 previous convictions, that became a life sentence in California. The 3 strikes you're outlaw has led to very long sentences for people. I think the big problem here, and this is something that you should investigate, and it's something we'll talk about in criminology if you take that class, or Introduction to Criminal Justice, I'll mention it, is there's a well-established phenomenon called aging out. That in fact, the sort of idea that you have these super predator criminals that will commit crimes for 10, 20, 30, 40 years. It's an interesting theory, but in fact, most criminals stop, particularly violent criminals, stop committing violent crimes. It's called aging out. And again, I'll let you look at that. Okay, on that note, we're right about at 50 minutes, which is as long as a class as I like to make these. We will come back with Chapter 9 whenever you're ready. Have a good day or night or evening or morning. Fare thee well.